certain orders to ensure that peace remains and law order remains on the ground. We have also accessed the full order copy of the Varanasi District Court, where the Order 7 Rule 11, that application of the Muslim side, has been dismissed. Pranshu Mishra is getting us all the exclusive information on this story. Pranshu, the 26-page order, could you take us through the key facets of this order? What is the reasoning really that the court has adopted?
Well, yes, we are, of course, the first channel here to access the entire 26th-page of this order copy. And we are already telling our viewers what are the primary observations as far as this order copy is concerned. The court has gone in details. It has mentioned in this 26 pages the arguments given by the Muslim side as far as their petition seeking the dismissal of the Hindu suit was concerned. It also talks in detail about the counter arguments presented by the Hindu side, the various sacred and the religious texts which they have mentioned, which they have cited in the court. So still we are saying that, we are still in the process of doing a detailed, minute study of these 26 pages and to come out with all the points. But the prima facie, what the court has clearly said is that, the Places of Worship Act of 1991 doesn't bar anyone from filing a suit to expressing his or her right to pray. And the suit which was presently in for the court's disposal was precisely of that nature, and therefore it is not barred. And the court said that, we are disposing of the Muslim side's petition, upholding the Hindu side's argument. We are taking up this case, that is the Ma Shringar Gauri versus the Gyanvapi case, for further hearing. And in that sequence, on 22nd, the court has called all the parties to sit down and decide the future course of hearing, which matters and which aspects need to be taken first.
It's only an initial legal battle that has been won by the Hindu side. The hearing at the district court has to happen. Any judgment or order of the district court is liable to be challenged at the High Court and the Supreme Court. So are we looking at decades of litigation yet again? Or this matter would be different and we would have some kind of fast tracking as Vishnu Jain was demanding. I'm cutting across to my colleague Ayushman. He's with us from the news cam, and he'll show us the key portions of that 26-page order that has come out from the district court. Ayushman, over to you. Take us through the key portions of that order.
Thanks, Anusha. This is the key part of the order where we can see the reasons that have been laid out for the rejection of the plea of the Muslim side. Number one, the plaint shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within the time to be fixed by the court, fails to do so, where the relief claimed is properly valued but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court. So these are the technical reasons why they've done that. Where the suit appears from the statement in the plaint to be barred by any law, where it is not filed in duplicate, where the plaintiff fails to comply with the provisions of Rule 9, provided that the time fixed by the court for the correction of the valuation or supplying of the requisite stamp papers shall not be extended unless the court, for reasons to be recorded. So these are the technical reasons why the court has rejected the Muslim side's plea. Bringing to the fore, number one, the main point that this has brought out is that under the provisions of the Places of Worship Act, this suit does not apply.
This suit does not apply. What is the places of the Religious Places of Worship Act 1991? This act under Section 3 says that if there is a religious place, a structure, you cannot change the character of that structure after 1947. So if in 1947 it was a temple, it stays a temple. If it's a mosque, it stays a mosque. Section 4 had the exception of the Ram Janmabhoomi dispute, which has now been decided decisively by the Supreme Court of India. Now here, the petitioners are saying that as of 15th of August 1947, remaining within the boundary of the 1991 Act, that was a temple. And not just a part of it, the entire complex was a temple. There were active prayers that were happening. It is only the Masjid committee eventually, artificially, created walls within the wuzu khana, destroyed the religious character and turned it into a mosque. That's their case before the district court, and they're saying that the original character is a Hindu temple, and that is why we want to go and worship there, where we are staying within the boundaries of the 1991 Act. Now, on the initial argument and on the initial objection that the 1991 Act applies, that's what the Muslim side said, and hence the suit is not maintainable. The 711 that we're talking about basically says that there is a law in place which you cannot bar, and hence a plea is not maintainable in civil law. The court says that no, if you say that there is a right to worship, you want to go to a temple, you want to worship it, and according to you it's a temple which has been a temple since 1947, the law doesn't bar you. Now, what the religious character is the entire complex really a mosque or a temple? All of these questions eventually will be decided by the court. Today is an initial victory for the Hindu side, a very important victory. More importantly, this is going to be challenged by the Muslim side at the High Court and could be directly at the Supreme Court as also, for the simple reason that the matter is very, very sensitive. You'd remember a survey which was already done. I'm once again cutting across back to my colleague Pranshu Mishra, who continues to be with us on the broadcast. Pranshu, let's talk to our viewers about the twists and turns this case has seen. Ever since that civil suit was filed at the district court, it has created a controversy of sorts. The matter also reached the Supreme Court of India. All hell broke loose when that survey videography was made public. There were, portions of it that went viral on social media, and the claim was that this is a much revered shivling which is there at a wuzu khana. And the Supreme Court even said that we need to seal that area and create the place for wuzu somewhere else.
Well, yes, this entire case, I mean, the Gyanvapi versus the Kashi Vishwanath case, we all know that there has been a lot of politics around it. There was a time when the political parties like, or the organizations like RSS and Vishwa Hindu Parishad always used to say, talk about Kashi and Mathura. But specifically, the legal battle, I'll say, started in 1991 when the first case was filed in the civil judge's court and which sought for a ASI survey. That case kept on lingering for 30 years, and it was only in 2021 that the court said that ASI survey should be done. But then that matter was challenged in High Court, and the High Court is still hearing up this case. Meanwhile, in 2019, another petition was filed by the 5 Hindu women devotees seeking the right to worship the Ma Shringar Gauri case. That case saw fast-paced developments, in 2021 and in 2022 when the civil judge court ordered for the Advocate Commissioner survey. In May this year, the actual action on the ground started with the Advocate Commissioner team going in for extensive survey of that entire area, the entire mosque area, the entire area where the fencing has been done. And for the first time in decades, the exact videography and photography of that entire mosque area was done. And it actually started, fresh chapters as far as this legal battle is concerned. Then we all saw that how the Hindu side, even before the court has taken cognizance of the Advocate Commissioner report, unilaterally went to the court saying that Advocate Commissioner's report says that the Wuzu Khana fountain is a ancient shivling and therefore it should be sealed. The court actually sealed that area, and then the Muslim side goes to the Supreme Court. Supreme Court refers the matter to the District Judge Court. District Judge Court starts hearing this matter sometime in last week of May. It hears this matter for almost 3 months, reserves the order, pronounces the judgment today, saying that, the Muslim side's argument that the basic very petition of Ma Shringar Gauri that was filed by the Hindu devotees is not maintainable, doesn't hold ground. The Hindu side's arguments hold ground on the premises that the Places of 1991 Act doesn't bar a suit which is demanding, which is seeking a right to worship. And in fact, this suit is not seeking to determine the nature of the place, but it is actually seeking the right to worship, and therefore now the trial in this case will start.
The trial will start. The initial hurdle has been done away with, an initial victory for the Hindu side. Pranshu, I'll come back to you because I want to talk more about this entire parampara that the Hindu side is talking about, which is about the worship of Ma Shringar Gauri. But before that,